Good morning. On behalf of STPI, I welcome you to session Assess on Health and Competition. May I please request our speakers to keep their microphone off when they are not speaking to ensure good audio quality for everyone. Speakers are also encouraged to switch on their cameras, especially when they are speaking, if their network allows to do that without any disruptions. The seminar will be recorded and the video will be posted online. You are welcome to revisit the discussion later and feel free to share with your network. We also invite questions from our audience and colleagues at the end or as the session goes. Please feel free to write them in the chat box or on the question and answer box on the right side. Please have the chat box open in the window as well, or you can also indicate that you want to speak by clicking the raise hand tab on the right side of the chat window. The session will also be telecasted live on STPI's Facebook page. For those watching us on Facebook Live, please write your questions in the chat there. They will be conveyed to the speakers through our team. Today's session moderated by Sir Pradeep S. Mehta Sahab. Now I handed over this session to Dr. Abis Soleri. So we may begin the proceedings. Thank you very much. Sir, your mic is off.
Thank you. A very good early good morning to Teresa and Hardin. Good morning to Pradeep and Uday, Akshay, Ujjwal. Good afternoon to Alan and good evening, Dr. Joseph Wilson. As you might have seen, this is a planetary panel where we have resource persons from across the globe. Teresa is joining us from Geneva, Hardin from South Africa, Alan from Australia, and Joseph is based in Canada now, while our CUTS colleague, they are in India. The topic that we are going to discuss is extremely important, access to healthcare and competition. And it becomes even more important in the times of COVID-19, where it's all about affordability and accessibility to healthcare. If we add, give it another twist and add the access and affordability to vaccine as well, I think that would increase its importance and its relevance even further. The role of competition commission, the role of competition, the role of access to healthcare, it goes beyond saying that in our region and in our countries, of course, competition commissions, while they are active, they're still struggling to have their footprints, and there's still they have to improve regulating a pharmaceutical industry. But when we look at it from pandemic perspective, I think that's where we need such a galaxy of panel and eminent panelists who can broaden our horizon. And I'm extremely grateful to CUTS, Consumer Unity and Trust Society, Jaipur, Delhi, and international. Actually, CUTS is international, and a very old friend of mine as well as of STPI, Pradeep Singh Mehta and his team for collaborating with us for this 23rd Sustainable Development Conference and for organizing this panel. Those who are not familiar with Pradeep's work, although he needs no introduction in South Asia, but those who are not familiar with his work, Pradeep is the pioneer in South Asia who started working on regional trade, regional economic cooperation, on WTO, on competition. That is how he's one of the founders of a network of organizations in South Asia called SAUTI, South Asia Watch on Trade, Economics and Environment. And he was part of many other important campaigns, many other important civil society movements, and especially inspiring us. I know in our transformational years, we used to look at Pradeep for his excellent work and his excellent access. So thanks, Pradeep, for being with us today. And I'll hand over back to you for further proceeding it further.
Thank you very much, Abid, for those very encouraging and complimentary welcome and remarks. And let me also join SDPI in welcoming all our panelists as well as the participants in this webinar on a very important issue, which has been explained by Abid to some extent. Let me take it a little beyond what has been spoken about. One is that we are celebrating the 5th of December as the World Competition Day around the world, and over 20 to 30 countries have been participating in it, including in Pakistan. The Competition Commission of Pakistan also organized events around the economic downturn rather than the theme of healthcare as was elected to propagate for this year's competition day. Now, the fact is what the CCP did was again extremely relevant, because there are another major disaster which is hitting the world is the economic downturn as a consequence of the COVID pandemic. So these are, they are sort of issues which are which can be conflated in many ways, yet the impacts would be deleterious in either case. Now, when we chose the theme of healthcare and competition, this resulted from a discussion we had at Geneva during the UNTAD Intergovernmental Experts Group meeting and competition policy. This is an annual event to those who may not be familiar with the world of competition law and policy, and we are therefore glad that Teresa, the head of the Competition and Consumer Policy branch of UNTAD, is also with us. So going back to this annual IGE, which happened last year, the South African Competition Commission, under the leadership of another of our panelists, Hardin, had organized a session on healthcare, and therefore we decided to ratchet the issues as being very important and major. Now, when we discussed it in July of the year 2019, we didn't know anything about COVID-19 or anything like that. Of course, we knew about various other epidemics and diseases which sort of are prevalent in the world. And the fact is that the cost of healthcare in the developing world is much higher as a percentage of the person's budget as against what it is in the developed world. In India, for example, what we found was that medicines cost nearly 50% of the treatment costs which a patient undergoes. And it is again, it is also a cause for poverty, in the sense that you're already poor, and then you will get sort of worse hit if your health goes down. Now, in that situation, there are two issues which arise. One is the, as Abid pointed out in his opening remarks, access and affordability. And access and affordability are often sort of compromised by anti-competitive actions by various companies. Now, what we have done is also produce a kit to sort of lay out the entire map of the healthcare issues in terms of competition policy and law, which can be accessed on our website, and I'm sure we'll be able to soon. I'll ask my colleagues to flash the link to that. Now, the celebrations took place all over the world, as I said, and we did a webinar on December the 4th out of our Geneva Center of Kutch, where again we had two panelists here who are also speakers, Teresa Moreira of UNTAD and Hardin of South African Competition Commission. So we are glad that they both are here in order to add a continuum, as it were, to the discussion that would be there. Now, The toolkit itself speaks about various ex ante and ex post uh, issues which can enhance healthcare, and particularly, as I said, and as Abid also pointed out, COVID-19 has raised the attention levels much higher, and it is a bit of a tragedy that just the other day a proposal at the WTO, the TRIPS Council, mooted by South Africa and India, to exempt vaccines from any IPR were rejected by the developed world. So that's an issue. We raised it in another manner in the discussion in Geneva on the 4th of December, was whether this is by Alexei Ivanov from Russia, who asked whether strong IPRs have helped innovation or not. I mean, the idea is to let us hit at the root of the problem. The whole TRIPS thing came up in the Uruguay round as something which could help to promote innovation and and so on. Promoting innovation is certainly one of the outcomes of any good competition law and policy. Now, to that extent, it is fair enough, but when it becomes exploitative or abusive, then what happens? So the issue which came up in the last webinar on 4th of December was to question whether IPRs have led to higher innovation, or is it the other way around? Has IPRs sort of, was it sort of, did it help innovation or not? And that was the question that arose, and that is something which you would like to discuss here now. Now, there are various dimensions to competition policy vis-a-vis healthcare, which we'll be discussing among our excellent panelists who are here. And what this, as I said, this toolkit provides is a very good understanding about the issue. What we've done is in that toolkit, we've produced case laws. We reproduced case laws across areas such as regulation and competition policy, patent laws, pro-competition patent laws, horizontal agreements, vertical arrangements, abuse of dominance, pay for delay. And there's another very interesting issue which comes up mainly in the pharmaceutical sector as an anti-competitive practice. You've not heard about it in any other sector, is that companies holding a patented item do not allow, what they do is they buy off any likely competitors that look, okay, you can come into the market at a much later date, there's no hurry about it. And in order to do that, they give them a cut or a price. That is something which I said was very unique in the pharmaceutical sector in terms of the competition policy rubric. Then mergers and acquisitions, privileged state litigation, and COVID-19 response. So there are sort of nine sections under which this toolkit has been covered, and I would recommend you to have a look at it in order to appreciate how important it is. Now, in the discussions, I mean, experts also reviewed some of the complex and sophisticated anti-competitive practices in the healthcare and pharmaceutical sector. These involved inter alia excessive and unfair pricing of patented drugs. Pay for delay agreements, which I spoke to you about, between patent holders and generic producers to delay generic entry and keep prices of drugs artificially high. Strategic mergers leading to monopolies or duopolies reducing competition, resulting in price increase and loss of innovation. There's an example of how innovation can be sacrificed. Then agreements such as exclusive supply or distribution, resale price maintenance, refusal to deal, etc. So a host of issues have been covered, which I think is a fairly explanatory toolkit. We've done it in a slide deck form rather than a book form, so that it makes it easy reading. With that, let me welcome you all once again to this session and invite, as I said, we have four excellent panelists. Dr. Joseph Wilson, former chairman of the Competition Commission of Pakistan. Joseph, about 7 to 8 minutes or 10 minutes. Over to you, Joseph.
Thank you. Can you hear me, Pradeep?
Yeah.
Okay. Well, thank you very much to SDPI and Kurtz for giving me this opportunity. When we were to talk about access and affordability in healthcare in uh, India and Pakistan, I think the starting point is to look at the constitution. And in Pakistan, it's Article 9 that says the right to life. And the parallel article in Indian Constitution is Article number 21, which is again right to life and liberty. And this right to life has been interpreted both in India and Pakistan as right to include to have basic healthcare. Now, basic healthcare, uh, there are a number of cases, and it goes further that the dignity of man, which is again a fundamental right, in Pakistan has been interpreted to include that the state must provide basic healthcare facilities in order to maintain the dignity of man. So when we have these um, public interest principles out there for healthcare, the concept of true competition might be different. But in order to see the access and affordability, I think what is the crux is the patent law. And we have cases both in India and Pakistan that talks about the first leading case coming from India in 2008, Hoffman LaRoche versus Cipla, which is an anti-drug, anti-cancer case. And in that case, what happened was Hoffman LaRoche filed for an interim injunction to stop Cipla, which was producing generic drug, anti-cancer drug, on the similar to patent of Hoffman LaRoche. The Delhi High Court refused to give interim injunction in that case, and it held that by giving them interim injunction, that would mean that the right to life is violated. Once you stop that, the access to the generic drug would be compromised, and then the court did not allow that. And this decision was upheld by the division bench and by the Supreme Court. So then we go on to another 2013 case in India that talks about, in that case, where Novartis challenged the denial of patent to its, this was a, uh, this was again an anti-cancer drug, Gleevec. The Supreme Court of India held that that whole decision hinged on the definition of invention, and the court held that any invention means anything which is new and not just by tinkering with already known technology or known uh, knowledge. So that way, then that case was it changed the dimensions of intellectual property rights, actually, not only in India, but all across the world. And what they had stopped was what is called evergreening. And evergreening is a minor modification to drugs with a way to extend the patent. And by doing that, what they by extending the patent, they block early entry of competition that drives the prices down. So this evergreening technique is hinging on is standing between both the access of medicine and also the affordability of medicine. These cases if we now look in Pakistan, the patent ordinance of 2000 defined what is invention. I think they got lead from, and it clearly defined that the invention has to be anything new and useful product or process in the field of technology. The court, high courts and their pronouncements have clearly established the nexus between competition and intellectual property. And the Patent Act of 2000 in Pakistan, it gives broad powers to the government for compulsory licensing and for revocation of patents. And the Section 58, which deals with uh, compulsory licensing, one of the clause deals with that where the federal government has determined that the manner of exploitation by the owner of patent or his license is anti-competitive, the federal government is satisfied that exploitation of the invention is in accordance with the subsection, could remedy that such practice by uh, compulsory licensing to other parties. So this section and Patent Act, it shows that in Pakistan, we have not given the monopoly of enforcing competition law to competition commission only, but it's the federal government also has the power to intervene when there are anti-competitive practices. This has another important case from Pakistan is Gets Pharma versus Federation of Pakistan, which deal with life-saving drug dealing with the cure of hepatitis C. Gets Pharma challenged the price fixed by government because it's in Pakistan, it's a DRAP, a Drug Regulatory Authority, which fixed the prices. And that was challenged, but the court upheld the price. And again, the reason was that the right to health and is such a right to life is a part of right to life, and the life-saving drugs have to be made affordable and have to be accessible to the general public. Now, these are some of the cases which uh, I think are important when we talk about affordability and access to healthcare. But coming back now to COVID 19 and what are the complications that has created, I want to show you if I can. There's a COVID-19 antitrust tracker by Allen and Overy law firm, um, which tracks all the exemptions given by antitrust authorities all over the world to different sectors, especially healthcare for collaboration. But my point, what I want to talk about is that uh, for example, in Pakistan, there are ancillary uh, ways in which the exploitation is being taken, is being consumers are exploited. And one such incident is where airlines have specified, especially the Middle Eastern airlines, they have specified from where the passenger must get a COVID-19 test and from where they get the COVID-19 test. Now, if there are laboratories which are authorized by the government to operate, and then by limiting certain laboratories to give to test the passengers, I think they are distorting competition, and that is an area where I believe Competition Commission of Pakistan can intervene as an instance of exploitation uh, through abuse of dominance, and this also comes under the time. I think this is something just to kickstart the discussion. I will give the floor back to Pradeep, uh, and I'll be available for any questions.
Thank you. Thank you. Thank you, Joseph, and thank you for highlighting the fact that our courts have declared our fundamental right to life, as which includes healthcare. So therefore, it's important to look at all these issues under the right to healthcare, which I think is probably existing in many countries explicitly or implicitly or through court interpretations. Uh, this is the very good case laws that you have recalled, and that would be very helpful in our discussion. But have a look at our toolkit. Now, this is a notice for all. If you look at the chat box, a hyperlink of our toolkit has also been given for your benefit. With that, now let me come to Teresa. Teresa, are you there?
Yes, thank you very much. I would like to share a presentation, if I may. So I will try
Please,
to.
please.
Thank you. Well, first of all, thank you very much to CUTS for the invitation, especially to you, Pradeep. And thank you for organizing always interesting discussions to commemorate the World Competition Day, that is to say, the approval of the UN set on competition by the United Nations General Assembly. Also, I would like to thank the Sustainable Development Policy Institute of Pakistan for the kind invitation. I will approach the topic from a very broad policy point of view. As you can imagine, I want to commend CUTS for the toolkit, as even though I only saw it very quickly, it seemed a very useful instrument, very informative, and really the right kind of tool to support, especially competition authorities that are less experienced of developing countries and countries with economies in transition. So for those who are less familiar with UNCTAD, we are the focal point for competition law and policy within the United Nations system. We are the guardians of the UN set of principles and rules on competition that, of course, have informed the adoption of laws and institutions in the past 40 years. So this year we celebrate the 40th anniversary, and this was adopted by the UN General Assembly on through a resolution in 5 December 1980. This is why CUTS has been more or less the pioneer, proposing the 5th December as the World Competition Day, and they always organize a number of events to commemorate this. Now, I wanted to also put this question in the broader context of the Agenda 2030. We know that there are only 10 years left for the 17 goals of the agenda that are a blueprint for economic growth and development of United Nations member states, and of course to each other international organizations have adhered. But I wanted to bring the SDG 3, good health and well-being, because I believe that the mention of universal health coverage, so accessible, as mentioned already, with quality, and of course affordable, is now more than ever important in the context of the COVID-19 pandemic. And a recent policy brief from the UN on COVID-19 and concretely universal health coverage really highlights the importance of this issue and of this discussion. Also, I would like to draw your attention to a recent UNCTAD COVID-19 issue, which of course gathers information and data that is recent, not exactly surprising, on the impact of the health crisis in the global economic shock, but also some more recent data on the number of COVID cases across the world, as you know, hitting very seriously the Americas and Europe, by contrast to most of developing countries worldwide, and also the number of deaths again. So underlining the role of competition policy in healthcare markets, but of course, always, let's say, facing a first hurdle in a way, which is due to the role and the weight of research and development in these markets and of intellectual property rights. Pradeep rightly underlined the very interesting exchanges that took place in the webinar organized by CUTS in the beginning of December. I do believe that nowadays, with all the discussions that we have been having on competition issues in the digital markets, it's probably about time to also start reflecting about the role of intellectual property rights and innovation, as it was very timely suggested. I would, in any case, underline that it would be important, of course, to continue this discussion or to have this discussion and conversation with representatives from the World Intellectual Property Organization, as usually we always interact more closely with World Trade Organization Secretariat colleagues. But it is clear that the importance of research and development leads to very high barriers for access for any new entrants. And we know even the difficulty of disseminating generics in developed countries when patents and other IP rights were no longer valid. Also, the price of pharmaceuticals and medical devices usually set through the intervention of sector-specific regulators is something that I believe competition authorities should refrain from interfering with, as it is so difficult to find the appropriate benchmarks, even though, of course, other concerns like the impact of the prices in public budgets, considering that governments tend to be a key customers, clients of these products and equipment, also plays an important part. Again, when talking about IP rights, licensing, also raises some issues, but it is true that case law, at least in Europe, the European Court of Justice typically has imposed licensing of IP rights, even in cases that did not involve the healthcare market. So as an exceptional, maybe a little bit invasive measure, but fully justified considering the interests at stake and the need for the balance. And of course, compulsory licensing being a flexibility for developing countries under the World Trade Organization TRIPS agreement. Now, I wanted also to mention, as Pradeep already referred, that last year, the Intergovernmental Group of Experts meeting of UNCTAD organized a roundtable on competition law and healthcare markets, thanks to the South African Competition Commission. And I thank again our good friend Ardin for having facilitated this. And even though you cannot really see this here, of course, we gathered a number of case law on pricing related enforcement actions all over the world. The same thing, examples for pay for delay, and of course, the examples of WTO flexibilities, relating to TRIPS and pharmaceuticals. I would like also to add that, of course, this issue raises a dimension of consumer protection, because consumers need to be informed, need to make informed choices, need to have information that allows them to choose and to understand, for instance, why a generic is a very good alternative to a medicine that is still covered by IP rights, for instance. And I believe that in the wake of the COVID-19 pandemic, and now with the vaccines being distributed, at least in some countries already, this is also something that is vital, so that at least there is enough choice, but there is also enough information for that choice to be effective. My final notes regard the need for for collaboration, for coordination, for interaction between policymakers, sector-specific regulators, competition authorities. Obviously, in the framework of such a pandemic, there are considerations that go beyond just the need for a competitive market. I think in any case, that is even the goal or the purpose of this discussion. But it is there is no doubt that competition policy and competition authorities should be involved in the design of any regulatory frameworks and should be actively engaged with pharmaceutical and healthcare service regulators in order to make sure that real competition considerations are taken into account, of course, combined with other factors, some maybe even of public interest. So it is very important that competition authorities are able to rebalance highly concentrated markets where, as we know, abuses of market power tend to be very frequent, and that competition authorities should not refrain from imposing measures, even if a little bit invasive, to restore competition, but let's say to make these markets work for the many and not just for the few. Thank you very much.
Thank you very much. Thank you very much, Teresa. That was an excellent contribution. With that, let me turn to Hardin. Hardin, over to you.
Thank you very much. Thank you very much, Pradeep, CARDS International SDPI, for the invitation. Indeed, this is a very timely discussion. As you have said, we started the discussion last year at the UNCTAD, and we do thank Teresa Moreira for allowing us space to engage on this and all the support to facilitate this discussion. I'm going to share my screen just so that hopefully within time. I hope you can see my screen now. Yes, so this I will of course have a disclaimer that the views I express here do not necessarily reflect the views of the Competition Commission or the government of South Africa. I need to state this because what I may say here there are discussions ongoing in the WTO, so I need to tread carefully there. There are a whole lot of things. I think the background has been covered very well by Teresa Moreira, the need for competition law enforcement. So what I'll focus on are the examples in South Africa. So I will touch on a case. We did it a while ago on ARVs. This case led to significant decreases in prices in South Africa. I will touch on what we did during COVID-19, the emergency enforcement, the measures that we put in place. I will touch briefly on policy developments in South Africa and then conclude. Of course, all of this we do to ensure we achieve the Sustainable Development Goals by 2030. Hence, the need for targeted policy response, targeted enforcement to address access issues. Pradeep, in his introductory remarks, touched already on the issues that we look at broadly as competition authorities: excessive pricing, pay for delay, and we also in South Africa, because we do have a private healthcare, quite significant in our market. So we look also at the efficient provision of private healthcare at affordable prices. There are pricing investigations, and I just mentioned this because this is an area sometimes where there's some controversy. Should competition authorities look at pricing issues? What we do is, I just show that in the UK, there's been a recent case, Pfizer claim, abusing a dominant position by imposing unfair prices for drugs. The EU has looked at cases, one against, a couple against the South African company, Aspen Pharma. India has looked at cases against Roche. This is a case, by the way, that we are looking at in South Africa, where we are investigating excessive pricing of a drug, a breast cancer drug, trastuzumab. We are experiencing some challenges on this case, of sourcing, actual pricing data from Roche, and we are exploring ways and means of procuring this information, and we've also started engagements with the UNCTAD to assist in these investigations, because in South Africa, when we investigate, they say, well, the information is not in South Africa, we have no right to ask them how much these drugs cost, and they cannot provide that information to us since we don't have jurisdiction over them. The case that I thought I would share with you is the case on ARVs. We did this. This is an old case, but very significant in the care for those living with HIV/AIDS in South Africa. We received complaints in 2003 against GSK and BI on pricing of ARV drugs. The prices were very high from early on. We investigated the case, and fortunately, the companies agreed to settle with us. But this is a case that we were going to prosecute, and we were confident that we were going to set a precedent. Drugs since then dropped significantly, and the remedies they agreed to was to grant licenses to generic manufacturers, permit the licenses to export the relevant ARV medicines to sub-Saharan African countries, and where the licensee did not have manufacturing capability in South Africa, permit the importation of ARV medicines for distribution in South Africa, only provided the regulatory approvals were obtained and other measures. We also impose other measures. So this is a case that shows that enforcement, even on patented products, can yield benefits, can yield results for those that need care. And we should not be shy to intervene when we find high prices in these markets. COVID, of course, has disrupted many of the things. We would have now to see, targeted enforcement actions. There are shocks that we have never, thought about, suspicious pricing behavior, but I'll talk, about this. We are seeing a lot of so-called rescue measures, but it is something that all authorities assist with. What did we do in South Africa as a COVID-19 enforcement response? We published regulations, so our government published regulations prohibiting price gouging during the pandemic. That if there were any price increases in South Africa without any cost justifications, authorities can use the competition law. We also used the consumer protection law. So that was a targeted approach. We received over 1,700 complaints. And To date, we have settled, reached 30 settlements with firms, and all of these complaints, the reason we generated these numbers, we made it very simple for consumers to complain. And what happened is most of the complaints touched on, the same products, face masks, sanitizers, and all of those products. And we have to date fined firms for excessive pricing over 9 million rands. We also had the firms contribute donations. Government established what it called a solidarity fund to address the challenges, especially for those that needed the support during this time. So we had firms contribute to this fund. There were exemptions to support the emergency response. We have had, exemptions to allow healthcare providers to coordinate on testing and treatment. We had exemptions for banks for debt relief. We had exemptions for retailers to assist their tenants to respond, especially in the malls that they may battle to keep up with the payments. We started tackling also food prices because there was a lot of panic buying, as you know. I've already summarized the cases that I have. So South Africa, we have 9 provinces. So we just show, where the cases are coming from. And the point here is that it's cases across the country. And Abid was talking about what, how we're able to reach out to even far-flung areas, through the webinars that we do. But also we picked it up that even now, with COVID-19, we even received complaints from places we have never received complaints as the Competition Commission. And early on, all the advocacy, I think, we participated, particularly, with UNCTAD events on, what ought to be the appropriate response, and that guidance, assisted us. The products that were mainly affected, I've listed them there. It's face masks, hand sanitizers, as well as basic food products. That was for price gouging. And we have intervened, and we have seen stability, particularly, on these products in South Africa as we continue to track them. I'll briefly say, South Africa has adopted a policy, just on policy developments on IP, just a few words there, to specifically focus on public health. And as Pradeep mentioned earlier, India, South Africa had made, called for the suspension of the protection of IP related to COVID-19 health products, but these, actions were not successful. But it seems to me the issue of pricing of these pharmaceuticals will still remain an issue. We are now seeing the rollout of vaccines, and will only help, once we see the prices, especially in developing countries. We have not even, the rollout has not started from our side. Conclusion and recommendations, and I draw on the discussion at the UNCTAD IGE in 2019, that healthcare must continue to be a priority to policymakers, sector regulators, and competition regulators. We should pursue and advocate for enabling policies for increased government expenditure in health services, prioritize competition issues in pharmaceuticals and health markets, especially medicine pricing, and get rid of these pay for delay tactics that tend to prevent new competitors from coming into the market, especially generic competitors. There's need for cooperation among competition regulators for better and effective enforcement. This we can achieve through bilateral engagements as authorities, but we can make use of the platforms we have at UNCTAD, ICN, OECD, where we can place this on the agenda and continuously engage. And I like, UNCTAD's thinking and motto that we should think debate, and deliver. And we should not be shy from debating these issues. We know that they are quite sensitive in some areas. But our view is that competition policy will remain an effective tool, and if used correctly and properly, can assist in ensuring that the prices of pharmaceuticals and treatment are affordable and accessible to the majority. Thank you very much for the opportunity, and I will end here. Thank you.
Thank you very much, Hardin, for another very excellent and comprehensive presentation about what is happening in South Africa, plus your own views on many other things that we spoke about. And we hope to continue with this campaign. Let me now turn to my very old comrade in arms, Alan Asher, who's the co-chairman of the International Network of Civil Society Organizations and Competition, which has been behind the World Competition Day, though cuts remains in the forefront. Alan has also been a former deputy chairman of the Australian Competition and Consumer Commission. Alan, over to you. Alan, are you there?
Turn on the microphone. Thank you, Pradeep. Just greetings to all participants. Just a few minutes to put a slightly wider perspective on issues of competition and healthcare in the context of sustainability. But firstly, on the issue of pharmaceuticals, which is something that that we've spoken of a fair bit, I'd also like to remind people that there was a conference that CUTS had, its biennial conference on, particularly on this issue of intellectual property and healthcare just a few years ago, and the website has on it quite a few papers that deal with this. It was the Fostering Innovation for Sustainable Development, Revisiting IPRs and Competition. So that's something that I'd suggest people who are looking for some empirical data might look up. My comments, though, are going to touch very, very briefly on aspects of some policies in relation to healthcare and sustainability, performance that we see, especially in developing countries, and then also prospects for the future. And on the issue of policies, there is a very close convergence between the goals of competition policy, which, as everybody listening would know, is about maximizing rivalry between competing providers to bid down prices and bid up quality. Healthcare policies, especially those at the national level, and of things like the SDG 3 on healthcare. So there's a real convergence of issues there. I believe that this topic has a special salience right now in ways that it didn't even 5 and 10 years ago. And the reason for that, in Pakistan, in India, and throughout Southeast Asia, where I've been looking at aspects of healthcare and competition over the last few years, and I've studied 10 different economies, is that in every case, there is a strong move to put more and more of healthcare into market situations. 25 years ago, in most developing countries, 90 to 95% of all healthcare services would have been provided by the public sector, public hospitals, clinics, and things like that. And that's reversing very quickly as more and more is being put out to private sector rival risk provision. And that's a mixed bag. I think there have been huge gains that in many cases, the provision of healthcare services by private businesses have rapidly and radically slashed costs and improved services. But in other cases, it's opened itself up to the traditional problems that competition laws were set up to deal with. And that is the problem of abuse of market power, dominance in markets, monopolization, bid rigging, and all of those things which we see across economies. And sadly, our policy makers have tended not to integrate the liberalization of healthcare with the need for a much stronger scrutiny from competition law and most particularly enforcement. And I'll touch on that again in a little while. But in my view, another huge gap in the policy setting and the inadequacy of laws in so many developing countries is that the competition laws have been developed and are being administered at an arm's length from the just as important consumer protection laws. And just to put my proposition quite simply, there's no real point in having a competition law which radically improves the efficiency of production and reduces costs of production distribution if all of those gains accrue to the supply side of the market and don't get through to the demand side of the market. That's why you need consumer protection laws to prevent deception, unconscionable conduct, unfair contract terms, and all the other things that bedevil markets. And so while there are lots of health policies that are moving in this direction, many of them actually fail in that way. And so my views about, especially at this crisis time of COVID, is that the competition policy instruments, which are, after all, designed about enhancing welfare, are not things which should stand outside that. And so the need for suspension of some of the arrangements that prevent collective action on distribution, and that's going to be profoundly important over the next year to 18 months in getting vaccines into villages. Even getting vaccines into major urban areas is going to require much, much higher levels of cooperation between the producers and distributors of vaccines and health authorities. To get it beyond that is going to take a mammoth task, and that's going to require a whole new approach, one that's quite possible under Australian competition law, and that is the temporary authorization on public benefit grounds of arrangements which would otherwise be in breach of competition laws. But other things are needed too. As participants have said in relation to pharmaceuticals, there are so many devices through which pharmaceutical companies are able to defeat the public interest and to defeat even those protective provisions that were put in the TRIPS agreement, and patent pooling, buybacks, and so many other devices, the extension and paying off generic companies are all standing in the way. And so just as there's a need for governments to modify some aspects of competition law to ensure that distribution can work in the public interest, there's also a need for the overriding or suspension of some aspects of intellectual property law for that very same reason. It's about consumer welfare. And in hearing developments in South Africa, I'm reminded that it's not really, it's still within living memory, the problems of AIDS and the way in which the treatment action campaign there took on some of these issues, even though it meant taking action against the South African government. So I'd like to make these points. Not only is pharmaceuticals an area of big concern for competition and healthcare, the delivery systems are too, and that healthcare is inherently open to anti-competitive practices. That's because there are large amounts of regulation. And if I think about things like medical devices, and especially equipment such as dialysis equipment, surgical implants, drugs, and all of the utilities, the building and services that go to it, each of those has a whole set of choke points where collusive conduct, price fixing, bid rigging, and other things can and do occur. It's my experience across the 10 ASEAN nations, and I said I've looked at this in some detail, where there is, in every case, you can look to those to find anti-competitive agreements which are costing a fortune. The same will happen in relation to distribution of COVID drugs and respirators and other things that are needed there. And so I believe that it is the case that every developing country, in wishing to take further steps, and I know Pakistan over 50 years now has moved a very, very long way in healthcare, and yet there's a need to closely integrate the competition policy development with consumer protection in order to crack down on many of these other ancillary healthcare market failures. The governments of themselves can't deliver that because there are institutions that are involved. And that means that institutions need to have good laws, good structures, adequate resources, and the ability to enforce matters through the courts or administrative systems. I mentioned that this was about policy, performance, and prospects. It's my assessment that though in most countries, most developing countries, the level of healthcare, growth of universal insurance and such things is improving, it's improving at a much too slow a rate to possibly consider any meaningful achievement of the SDGs over the next 10 years, and that radical further action is needed. The prospects are mixed, and that I believe that I'll just finish on the single most important step that I think developing countries can take, and that is to focus specifically on the enforcement of existing prohibitions under competition laws and under consumer protection laws, put those together so that consumer welfare can gain. And by the way, governments acting alone can never do that. Governments have to make much, much closer partnerships with civil society, groups like CUTS in the many jurisdictions in which it operates, the very powerful consumer groups in Pakistan and elsewhere. They are ready, willing, and able to help their governments and enforcement agencies in doing their work. But I find that so often government agencies are somewhat afraid of discussing these things with civil society for fear of getting into trouble with their government policymakers. It's my contention that absent powerful new alliances with civil society, not just nationally, but internationally, governments and enforcement agencies will fail. So the prospects are that with good cooperation, that successes can be achieved, and that the SDGs 3 and others relating to health can be achieved. But a timid approach to this, a failure to be bold in engaging with civil society, and a failure to use enforcement tools as they're written will lead to a shortfall in outcomes. And they're the comments that I would like to make, and thank you.
Thank you. Thank you very much, Alan. And we are actually coming closer to the end of our session. However, there is one question which has been raised by Uday Mehta, my colleague. But before that, let me compliment Alan on his excellent presentation, and particularly two among other things which I take is SDG 3. I mean, somebody else also, I think it was Teresa who also spoke about the SDG agenda and how does it relate to that. So we do have an international instrument in place. And the SDGs also talk about civil society participation in many goals, to achieve many goals. So let us not forget that there is an excellent international instrument agreed to by all governments to deal with these issues and through a cooperative effort with civil society. In fact, if panelists would remember, even the audience, it was civil society's action which led to the TRIPS, to the Doha Declaration of TRIPS in public health. It is not a policy issue pushed by governments, but it was pushed by MSF and Oxfam that we got that TRIPS in public health declaration, which is again very critical for our discussions here. And that is a question which has been raised by Uday, that since the TRIPS already allows these flexibilities, don't you think that the flexibilities can be used by countries, including the Doha Declaration, as I spoke about, allow other countries to be able to produce generic versions or compulsory licensed versions of vaccines which will come into the market? So let me start with you, Alan.
Certainly.
Very
I don't
briefly,
believe,
another 30 seconds,
yes.
40 seconds.
Sure, 30 seconds. I don't believe that the TRIPS provisions are going to be effective, because since then, there are now so many bilateral trade arrangements where those TRIPS provisions have been traded away. And also the complexity of the copyright issues, access to testing protocols, and all of those things which aren't really covered by the TRIPS exemption mean that it's been largely rendered ineffective. It's a tragedy, but that's the way it is.
Thank you, Alan. Joseph? Is Joseph still there, or has he left?
No, I'm
Probably
here.
very late in night. Oh, Joseph, welcome.
Yes.
Your views, please, about 30 to 60 seconds.
You know, if you were to look in Pakistan, there's a clear public interest provision in Section 58 of the Patent Act, where the government can ensure compulsory licensing if the public interest so demand. So I think you know, in the case of India and Pakistan, it's possible that the COVID-19 vaccine could be the patent could be given for generic purposes.
Thank you. Thank you. Alan made a very important point, which is what I would like to reflect about, you know, and there are many bilateral agreements which the US has entered into where there's TRIPS plus provisions. Now there is, Alan, there is a big pressure on India also by the US in terms of our trade relations to relax our Patent Act issues which Joseph spoke about, for example, evergreening, etc., etc. But we refuse to relent. Well, I think the point which you made is evident in the way the US and India relations on TRIPS or on IPRs is developing. Hardin?
Thank you very much. As I've said, there are developments in South Africa, but what I've seen is that the TRIPS agreement in and of itself is not an automatic tool for reform. You know, and the example in South Africa is quite pertinent here, because the laws in South Africa, in fact, the policy, as I've said, has just been developed on IPR. Before then, you know, it has been very, very easy in South Africa for firms to register patents. And we will only see, and by the way, the constitution also comes into play here. We'll also see how this policy will translate into law to then encompass all these principles of TRIPS, which is, you know, parallel importation, compulsory licensing. But as I've said, some of the things we've been able in the interim to achieve through the enforcement of competition laws, you know, in line with what Alan is saying, with, you know, had we waited for the policy, I think if you look at the intervention in 2003, that would not have, you know, we would have had a huge cost, you know, to the patients. So my view is it's how domestic you know, how governments respond and how governments translate these into action and policy in their own territories. So this is it can be there. It's a good you know, agreement, but if it's not translated into some tangible actions in domestic economies. And the South Africa example shows that the delay has been there. It's 2020 now, but the patent laws have not been reviewed as yet.
Thank you very much, Hardin. For the last word, Teresa, as UNCTAD, which has been most supportive of the developing countries' interest in the international economic arena, I would not say trade, but the whole international economic arena is something. There's a very big burden on UNCTAD to take forward some of these issues in a way that individual countries, small countries, do not get sort of swept aside from the protection of what we have already agreed upon. And I mean, I and Hardin just spoke about the example of the latest discussions where we wanted India and South Africa moved a paper in the TRIPS Council to get a specific exemption on COVID vaccines, but that didn't succeed. But as our understanding is that the existing flexibilities allow countries to use that. Over to you, Teresa.
Thank you very much. Well, UNCTAD, of course, has always encouraged developing countries to make use of these flexibilities. But as Alan mentioned, and Ardin, Joseph, of course, the multilateral trading system has been somehow undermined by this rise of bilateral and regional trade agreements that could also be convergent and coherent, but we know very well that in such a important, sensitive topic, it's not really the case. So, of course, I think the concern is that the developing countries, or especially the least developed countries that really have very little bargaining power and have not necessarily entered in this type of bilateral agreements, or if they did, they probably did not have enough leverage to get a fair deal, cannot be fully protected. So I would suggest the following: why not bring up this topic in the broader context of the UN? Because that's why we have the Sustainable Development Goals. There was a huge UN COVID-19 response with concrete projects trying to target different sectors, different situations, different groups of individuals, of populations that were hit very hard by the pandemic. Why not bring this as a really public interest health issue? There's nothing more important right now. And I think that this could very well be a very good case for an international coordination. Now, having said this, I would agree with Alan and other speakers that I think competition authorities and consumer protection authorities at national level always will have a very important role to play, because they can resort to measures to stop abusive, to order compulsory licensing, and to rebalance these practices. I'm not saying that they are the ones who should have the final say. I do believe that this should come from a governmental coalition, so to speak, where, of course, civil society organizations should be very much welcomed. But I do think that competition and consumer protection authorities working in tandem can have a major impact. Thank you.
Thank you. Excellent, very good remarks, Teresa, and I think we'll take it forward. I think what I see as an outcome of this discussion is to develop a draft, unless it is already being done, a draft of TRIPS and Public Health Volume 2, or Edition 2, I would say. From Doha, we take forward now this particular issue and then cover it and include SDG 3, etc., and all that. Something which we should forward. We'll take it up with MSF and Oxfam, which are probably leading international organizations working on this. And I'm sure there must be thinking going on these lines to take it forward so that we are able to get a better understanding. And maybe at the next WTO ministerial, whenever that happens, that we are able to then file this paper as we did in Doha, As I said, I just want to remind everybody that civil society has been instrumental in getting governments to agree to TRIPS and public health declaration, rather than it was something which came out from government thinking as such. With that, I would like to, we are coming to an end to all this session, and let me again thank SDPI to organize this particular session. Usually I would have been there personally in Islamabad, which is always such a delightful conference that has happened. The kind of energy, those of you who have not seen the SDCs, I've been to many of them, and the amount of energy which floats in that atmosphere is just fantastic. It sort of regenerates you, and as I said, as Abid recognized me as somebody who's been a pioneer in a lot of regional cooperation work in South Asia. I really miss not being there physically. Of course, one great disadvantage with virtual meetings is that you cannot network. You can only, talk, have a dialogue or a multi-log, but you can't network. And quite often, many issues you discuss and resolve in the corridors or over lunch or dinner or tea or something. That is something which I'll miss again. With that, let me hand over the proceedings to Zara. Zara, for the concluding. Zara, are you there?
Yes, sir, I'm here, but I think so. Avisa will conclude
Oh,
much
is
more better
Abid
than
there? Yeah, I thought he's probably gone for another session. No.
No, he's here.
Okay.
Thank you very much, Pradeep, and all the distinguished panelists.
अभी चाय तो पिलाई नहीं.
चाय अभी अपनी अपनी ये पिए ना, ये देखें. This is the virtual chai that we can have.
Okay.
But Pradeep, I wanted to take 1 or 2 of your minutes. If you can share your screen and show your toolkit, I think.
Yeah, that's a good idea. Yeah, that's a good
so
idea.
Akshay,
yeah, no, you were right.
Minutes. Yeah.
No, Akshay. Yeah. Akshay, do you have the hyperlink also? You've already put it there. This is how it looks, friends. This is what the toolkit looks. It's a slide deck. So it's now the more sort of reader-friendly format rather than a big book or booklet or something like that.
Can we? Yeah.
You want them to go through the whole thing?
No, we just want to get.
Yeah. Akshay, this is enough. Yeah, this is how it looks. Yeah. Okay.
Yeah. So Pradeep, thanks for sharing the link and all the participants. And I can see there are around 59 on this link, and there are many more watching a live stream on our social media pages, Facebook and STTV pages. So I'll encourage all of you to please visit this toolkit, get an idea not only about your rights, consumer rights, but also that how we can support our governments and respective competition regulatory authorities in our countries. And I'll echo and I'll endorse Mr. Alan Asher's point that it's our collective responsibility. No single government or no single competition regulatory authority can do it on its own unless and until the consumer groups, civil society, academia, media, we strengthen the respective regulatory authorities. And thank you very much for highlighting the very pertinent points in the context of COVID-19. As you could see that the whole concept of this conference is sustainable development in the times of COVID-19, and sustainability, sustainable development, the two pillars, which is social justice and peace. I think that cannot be achieved unless and until consumers and manufacturers we could balance in their rights and obligations. And in order to balance their rights and obligation in healthcare sector, accessibility, affordability, patenting, and equitable access to the vaccine that would has already been administered in some of the developed countries. I think those are important. So waiting and looking forward to some normal times when we can network, as Pradeep said, and exchange our ideas and thoughts over a cup of tea. I would thank all of you, and I look forward to welcome you in person next December 2021, inshallah, when we will be able to have in-person SDC. Thank you, Pradeep.
Thank you. Thank you very much.
Thank you.
Thank
And the
you.
Bye.
recommendation of this panel
Bye-bye.
would be forwarded to all the authorities, relevant authorities in Pakistan, and we'll also be compiling the report, and we'll expect that you will also be able to send it to your respective authorities and respective decision makers. Yeah. Thanks, Pradeep.
Thank you.